Hello, everyone. Thank you for joining us for the Death Penalty Focus webinar, Alameda County, California Prosecutors and the Exclusion of Jewish and Black Jurors. I'm Mary Kate DeLuco, Communications Consultant at Death Penalty Focus, and I'm here with my colleague, Yoko Otani Sperlin, who is the Business and Finance Director at DPF and running everything behind the scenes. This webinar is being recorded and will be available on the DPF YouTube channel in about a week, a little less probably, but we always like to leave room for it taking longer than we're used to. So welcome again, and I'd like now to turn things over to our moderator, Death Penalty Focus President Mike Farrell. Mike.
Thanks very much, Mary Kate. Hi, folks, and thanks for being with us today. As Mary Kate suggests, I'm the president of the board of directors of Death Penalty Focus. And we are happy, really, to be able to present these webinars on different subjects pertinent to and surrounding the death penalty to help educate people about the barbarity and the stupidity of the death penalty and the wrong-headedness of those associated with kind of promoting it. And today we have really, I think, an exciting and extraordinarily interesting issue to deal with. Our guests today are two defense attorneys, Brian Pomerantz and Ann-Kathryn Tria, who are co-counsel for Ernest Dykes, who was sentenced to death in Alameda County in 1995. Alameda County, California. His death sentence appeal in April was the catalyst for the discovery by the Alameda County District Attorney's Office of notes indicating that prosecutors in his case had excluded Jewish and Black jurors from his original trial. That discovery led a federal judge to order the Alameda County District Attorney's Office to review all 35 death sentences imposed in the county in the past 30 years for evidence that prosecutors may have systematically removed Black and Jewish people from serving on a jury. Brian and Ann-Kathryn, welcome. Thank you very much for being with us in what I can only imagine is an incredibly busy time for you.
Yes, thank you for having us.
It's a pleasure. You two serve as co-counsel to the man whose case is the catalyst for this whole investigation, into whether prosecutors in the Alameda County District Attorney's Office systematically removed Black and Jewish people from serving on a jury. Can you tell us a little about the Ernest Dykes case, Brian? You told the New York Times recently that you've spent 10 years trying to expose jury bias in capital cases, even calling it your life's quest. So with Mr. Dykes' case, did you think this case could be the smoking gun in the question of systematic jury exclusion?
Actually, no. I thought some other cases could be. I did not expect that this one would be. We got on Mr. Dykes' case just late last year, and so I have two other clients in Alameda, Mark Schmeck, who I started representing a decade ago, and Charles Stevens, whose case I've had for about 8 years. And it was in Mark Schmeck's case that the attorneys prior to me had worked up claims that Jewish jurors were being struck improperly. And when I got Charles Stevens' case, I found more of that, and also that Black jurors were being struck improperly in his case. And those are claims that we've been litigating for many years. In Mr. Stevens' case, it was unsuccessfully. The courts repeatedly denied it's called Batson claims, the U.S. Supreme Court case, one of the U.S. Supreme Court cases on the matter. They denied his Batson claims, but it's something that has been a very poorly kept secret in Alameda County is that they're doing this, right? Defense attorneys have been saying for some 20 years that this is something that they've been doing, and the courts have not taken the steps to reveal.
Mm.
And so in the course of getting Mr. Dykes' case, Ann and I looked at the case and we thought that a black juror had been improperly struck in that case. And in a conversation with someone from the DA's office, we raised our concerns and we challenged them to go look at their files. And to their credit, they did. They went and looked and came back and said, yeah, there's a problem here. And there were a few steps in between, but eventually, as you know, it led to the press conference that District Attorney Price had, where she brought this to everyone's attention and said, this is a problem that goes way back, and we're going to look at these cases.
It's amazing. What I can't fathom is that questions about and evidence of jury exclusion in Alameda County, as you say, hasn't been a secret. I read an article from the New York Times from March 2005, almost 20 years ago, about an Alameda County Deputy DA, John Quatman, stating in a sworn declaration in the habeas corpus case of a man he prosecuted at the time, that the trial judge in that case advised him to exclude Jewish jurors because, and I think the quote was, no Jew would vote to send a defendant to the gas chamber. So how does this jury exclusion continue for another 20 plus years? Was Batson never raised, or was it simply not applicable? Ann-Kathryn?
I think Brian's got some kind of statistics on that, but it certainly was raised all of this time. I think you had a district attorneys in the office before Pamela Price who didn't want this to be revealed. And you had claims raised in the courts that the California Supreme Court just consistently denied them. So I think, again, like I said, Brian has some statistics on that, but the California Supreme Court appears to have not taken the claims seriously, in my opinion, and not looked at them adequately enough to see that there was a problem here.
Brian, how's that?
When Jack Quatman essentially became a whistleblower, instead of really dealing with the problem, what they did is they attacked Jack Quatman, and they said he was untrustworthy, and there was a sham hearing in which a bunch of prosecutors from the Alameda District Attorney's office took the stand and said this is not a reliable person. And he was wrongly demonized, and the courts, instead of looking at the problem, were happy to take the whistleblower and make him a bad guy. And the California Supreme Court has a bad history with Batson, and that, don't take it from me on that. One of their justices keeps saying it. Justice Liu, who's currently on the court, has written numerous concurrences and dissents where he has taken issue with the court, saying that they're not handling Batson cases properly. In a case from a decade ago, People versus Harris, he said, in more than 100 cases over the past 2 decades, this court has found unlawful discrimination in jury selection only once. One need not question the overall excellence and integrity of our prosecutors and trial courts in order to pause and wonder, in light of the remarkable uniformity of this court's Batson decisions over the past 20 years, whether we have maintained the proper level of vigilance. I have serious doubts. And that's the problem. In 136 out of 138 Batson cases over the last 30 plus years, the courts found no problem. And in the 2 they did, they were both Hispanic jurors. They have not found an improper striking of black jurors for 35 years in California.
Wow.
So this is how this continues. This is how we get to this point 20 years later, where it's news.
Now that's Judge Chabria, was it?
No, that was Justice Liu of the California Supreme Court, who said that about his own court. And then Judge Chabria, federal district court judge in San Francisco, is the judge who is overseeing there was a previous recommendation to settlement conferences for Ernest Dykes, and Judge Chabria is overseeing that. And so it was in the course of that he, when we brought this to his attention, put out the order saying, I want to see the discovery from the other 35 cases. We need to see if this is happening everywhere or if this is an outlier. And we've collected tens of thousands of pages of discovery from the DA pursuant to that order, and it is certainly not an outlier. This is systemic.
In the wake of that order, you mentioned Judge Mark Schmeck's case. He was sentenced to death in 1990 and challenged the prosecution's removal of 2 Jewish jurors from the pool at his trial in '89, and again in 2005 when he appealed to the California Supreme Court, again alleging that 2 prospective jurors were excluded from his trial because they were Jewish. That's now appealing and is now appealing again. His first appeal was rejected by the trial court judge, who accepted the prosecution's explanation that they were removed because of their doubts about imposing the death penalty. His second appeal was denied in a unanimous ruling by the California Supreme Court. Do you think this is the first of the 35 cases that we're going to see challenged now? And if not, why not? And if so, do you think this current state Supreme Court will now be more open-minded on the probability of jury exclusion?
I'll say I certainly think we'll see more challenges now. I know there were some challenges under the RJA in the courts when this information was revealed in Mr. Dykes' case. So those are still pending and being litigated there. Then, of course, we have Brian, who filed a challenge for Mr. Schmeck. It's something I'm looking at, and I have another case out of Alameda looking at whether that's something that needs to be done for my other client. And I think the other attorneys there are doing the same for theirs. The one problem is that there are a number of people with capital convictions in Alameda County who have pending appeals in the state court, but they don't have counsel. So one of the things we've been brainstorming is how we help those people and what we do about that situation, because obviously that's a problem for people that may have these issues and likely do have these issues, but don't have anyone to advocate for them at the moment.
Wow. So from what you know of this systematic exclusion of Black and Jewish jurors, were they, for example, only excluded if the defendant was Black or Jewish?
No, the short answer is no. It was about the jurors and not the race or ethnicity of the defendant compared to the jurors. So basically, what it appears is the prosecutors believed that Jewish jurors and Black jurors would be less likely to convict a defendant, and then if they did convict, even less likely to impose a death sentence. So they didn't want those jurors on their capital juries, regardless of what the race or ethnicity of the defendant was.
So, Mark, you're raising this issue on the Schmeck case. Ann-Kathryn, are you raising it in your case as well?
Yes, I am. It's something, we've been appointed in also these 11 cases in federal court as well to kind of facilitate settlement and review everything. So I'm currently focusing on a lot of those, but certainly looking at that in mine as well. I'm waiting to receive discovery, to be honest, in my case, which will affect what I do. So I've kind of moved that a little bit further back while I'm doing other things so that I'm not wasting time.
Gotcha. Now, I'm guessing that, I'm sorry, Brian?
No, I was just going to say, we collected approximately 50,000 pages of discovery from the cases that weren't Ernest Dykes' case. There were about 10 cases where they had no discovery for us. The files have mysteriously disappeared. And so some of those teams are hoping that the Attorney General's office may have files, but some of those teams will simply have none, nothing to work with. And so obviously they'll have to rely on the systemic claim, but they won't have direct evidence from their case per se. Now, how those disappeared, we could speculate all day long, but that there are some patterns to certain prosecutors. Stuff are gone, and other prosecutors' stuff are there, and things like that. Not not uniformly across the board, but largely. There will definitely be more Racial Justice Act petitions. I think you'll see them from a lot of the people who aren't in federal court. You'll see them from some of the federal court people. I've drafted one for Charles Stevens. I have not filed it yet, but it's done. So there will be more of those coming.
Well, now I'm guessing that prosecutors systematically excluding Jewish and Black jurors is not unique to Alameda County. Investigations of DA's office in all 58 counties could quite possibly reveal similar practices, do you think? I think what surprised so many is that this occurred in the Bay Area county that has a very diverse population. The current DA, granted, as you say, she's fighting it, she's facing a recall election. She's a Black woman. Do you think we'll hear more of these cases like this from around the state?
Should we hear more, or will we hear more? Two separate questions, Mike. I'm not sure. Do I think we'll hear more? Probably, sadly, no. Should we hear more? Yes. Do I think it's happening in other places? I believe it's happening in other places, not just in this state. It's happening across the country. I mean, I have Batson claims in cases across the country. I have one in a North Carolina case, one in a Kentucky case, one in a Utah case. And I have one from another county in California, from Tulare County. So I think it happens in a lot of places. I think what's unique here is that we were able to actually get the proof of it from the prosecutor themselves, which is incredible. I mean, it's very hard to make these out because, as I said earlier, the courts don't have a real desire to upset these cases, and they will make excuses quite a bit for why something wasn't really racial, even though it looks like it was racial.
Yeah. Ann-Kathryn, is that your experience as well? Now, did you indicate to me that you've been given these 11 cases on this basis?
We've been appointed just to help facilitate settlement and review of all the documents that we've received,
I see.
because this was revealed in Mr. Dykes' case, and then Judge Chabria said, I want to see, whether this is more systemic or just limited to this. We were tasked with receiving those documents and reviewing them, and now we're assisting counsel in those other cases with interpreting those, reviewing them, and hopefully facilitating some sort of resolution in cases that have these issues.
Okay, well, with this, I mean, you've got it's like the pulling the finger out of the dike. What happens now? Where do you go from here in both your cases?
And you want to take it?
That's a good question. I think I'm hopeful that DA Price's office just continues working with us, taking this issue seriously and reviewing all of the cases to determine how these issues, clear constitutional violations, can be resolved.
Is she supportive in terms of what you're doing?
I mean, it appears that her office is taking it seriously and reviewing it. I think, as Brian said, we encouraged them to go look at their files, and they did find this, and they did take it seriously at that point to say, here's what we found. So we're hopeful that continues, and so far they appear to be reviewing the files just as we are to see what else is there.
Brian?
I think they're trying to figure out what the right results for these cases are, and they're taking their time to look at them and to say, this case looks wrong, and it looks wrong for the following reasons. I mean, some of the stuff we've gotten it's frankly incredible. I mean, it's just incredible things to see. This isn't just necessarily writing this person's black and I would prefer not to have them on a jury. I mean, some of the stuff is really awful things they're saying about jurors, and these are not, in almost all of these cases, these are not current prosecutors in District Attorney Price's office. These are people who were prosecutors, in some cases going back to the 80s. But the most recent death penalty case out of there is 2016, which was before her tenure. So none of these were tried under her watch. None of these were under her leadership, and it's they're doing their diligence. Would we like it to go faster? Of course, right? We want instantaneous. That's not realistic. They're working hard. They're working very hard on it. I'd like to see the Attorney General's office, involved as well. I mean, I think they're looking at cases. They're doing review, but we've heard very little out of them. I think one of the things here is people are looking at Pamela Price a lot, but the DA has jurisdiction in a number of these cases. Excuse me, the AG's office has jurisdiction in a number of these cases. So the AG's office, as well as the DA's office, can right these wrongs. It does not need to be the DA that does it. For any of the people who are in a court where the AG has jurisdiction, which most of these people are, the AG can concede claims. So they can simply say, you know what, we've looked at Mark Schmeck's case. We're deeply troubled by what happened here, and we're conceding the Batson claim, and he gets a new trial. And that's something that we're encouraging them to do in cases, as well as encouraging District Attorney Price to look at resentencings in cases. So hopefully we'll start seeing some of these move.
Now, you've mentioned, Brian, that you got other cases outside of California. Do you find the same issue ripe in other places?
Batson can take a lot of different forms, right? So it's here it's striking Jewish jurors and black jurors. In my Utah case, it was striking non-LDS jurors. They wanted an all-Mormon jury. And so they were striking non-Mormons. So it takes different forms in different places. In my in my North Carolina case, they were striking black jurors. So I mean, some's the same, some's different. It's how it's the problem is it's trying to gain an advantage by getting rid of people based on their group and not judging them by the people they are.
Mm-hmm.
And that's the harm, and that's what you're not allowed to do. That's what the Supreme Court has said over and over again. You can't do it this way, right? You have to judge Mike Farrell by Mike Farrell, right? You can dislike Mike Farrell because Mike Farrell was an actor. But you can't dislike Mike Farrell because Mike Farrell is white.
Gotcha. Yeah, well, and a lot of people dislike me because I'm an actor, but but would you mind? You said you can't believe some of the things when you're doing this research that you find that prosecutors say about jurors. You mind you offering a couple of instances?
I mean, some of them were jurors who were really good jurors for the prosecution, jurors who strongly believed in the death penalty, jurors who normally a prosecutor would have loved. And we see notes where it would say, white female, Jewish, they underlined Jewish, and that's a strong death penalty, right? Because this person had rated themselves as someone who believes, in the death penalty, they had a ranking of like 1 to 5. They were, at the top ranking on that. And then it said, but no way, because she was Jewish, right? No matter how good you were in every other respect, if you did not fit, if you were Jewish, you're out. And that's not just Ernest Dykes' case. That is in dozens of cases. There was one known juror who sat in a capital case in Alameda in the 80s and 90s. One, and that's because they ran out of peremptory challenges. They couldn't get that person off the jury, so they had no choice. We're seeing a lot of stuff that isn't Batson specific, doesn't have to do with people's race, but it's just appalling. I mean, talking about people's appearances, in a lot of them, they talked about how women looked, either positively or very derogatorily. Uh, it, a lot of it's stomach churning. I mean, a lot of it is just really like, what is wrong with a person who would write this about someone who's just come in to do their civic duty, right? They're just there to do their thing. Most people don't want to be there for jury service. I know that seems incredible, but most people don't want to be there for jury service, and yet you're there, you're doing your part, and here's people who are looking at you and writing down how you're dressed, how you look, whether you know, and making comments about it, and it's that's not, sadly, that's not unconstitutional, that part. It's just disgusting. And Ann and I get to read all of this, so it's fun.
Yeah.
It's actually kind of it's really dark. But there's also stuff where they're talking about, you know, there's comments. There's a lot of comments about Black jurors where they would say, she said she could do it, it being the death penalty, that they could give the death penalty, right? It's a common question. That's something you ask all jurors. Could you actually give the death penalty? Right. And they'll write, she says she could do it, but I don't believe her. And the I don't believe her or I don't believe him are 99% of the time, they're Black jurors. They didn't believe Black jurors, right? If a white juror said the same thing, there's no such comment. I think I've seen it like one time with the white juror. I've seen it dozens and dozens of times with Black jurors.
Yeah. I don't know that I can even recall that one that I've seen with the white juror, but very often with the Black jurors that just says, I don't believe her. I don't believe him.
Yeah.
I think he's lying.
So if a juror says he or she cannot give the death penalty, that you can strike them. There's legitimate cause for that.
Yes, you can strike them for cause, which means you don't have to use a peremptory challenge. Peremptory challenge is a challenge that it's like a freebie challenge, right? You get so they don't. Those people are struck for cause, so they don't even make it this far. Mm-hmm. So these are the people who are in this situation, the people where they're striking with peremptories, are people who've passed for cause, the people who've said, I can do this, you know, or I believe I can do this. And the court has been satisfied that at least, you know, maybe they're not 100% sure, but they're also not 100% sure they can't. And so they're going to inquire more. And it's fine to ask more questions to try to fine tune that area of whether someone will give the death penalty or not. What's troublesome is when you're saying, I don't believe people, and the people you don't believe are Black, right? That to me speaks of racism. That doesn't speak, that's saying something far beyond what the jurors say. That's more about the prosecutor than the juror.
You'll also see that a lot when they do go back and question them. So if they have like the juror questionnaire that they fill out and they put they're not sure about the death penalty or something like that, and then they bring them in and question them individually, you'll consistently see like if there's a white juror and a Black juror that have the same answer, like they both check they're neutral on the death penalty or they're not quite sure. The white juror will come in for questioning and they'll ask a couple questions. Well, you're not sure, but you think you could. Like, yeah, I probably think I could, maybe. And then they stop. And then the Black juror gets up and they ask, like, well, you said you weren't really sure. You said you're neutral. What does that mean? And they're like, yeah, you know, I'm not 100% sure. I have to see the evidence. And they'll just keep asking them question after question after question, badgering them until they get kind of like the answer that they're looking for that will give them in their mind a reason to strike them.
Well, this is, you know, none of it is surprising, but it's awful to hear just the same, and particularly for those of you who are in there able to read these transcripts and interview the jurors and do the kinds of things that are necessary. Tell me what, if anything, we as DPF can do, and DPF and our coalition partners do to support you and the other lawyers working on cases like this. Is it enough to continue shining a light on it, or is there more we could do?
I think shining a light on it is huge. I mean, I think one of the important things that's happened here from this is the attention it's gotten is important, right? It's important that, especially in California, part of the dark history of California on the death penalty has to do with going all the way back to Rose Byrd, right? It goes all the way back to that court in the 80s that was giving relief in these capital cases. And there was a concerted effort to vote the justices out who were doing that. And I think that is why 40 years later, we have justices who are afraid to overturn these cases when they know something's wrong, because they don't want to get voted out. In California, that's what happened before, and people don't want to get voted out. It's not hard to see problems in some of these cases, right? In Charles Stevens' case, 7 out of 8 potential Black jurors were struck. 6 out of 6 potential Jewish jurors were struck. Those numbers speak for themselves. In Mark Schmeck's case, he was unapologetic. The prosecutor was unapologetic about striking the Jews. He actually said on the record, after he was challenged for striking the first 2 Jews, the defense attorney said he struck 2 of the 3 on the panel, and he said, "Who's the third?" And when they told him, he said, "If she makes it to the box, I'll kick her too." He was unapologetic about it, right? How did these cases go through the California Supreme Court with the Batson claims, which they had in them, and lose? This is mind-boggling to me, and yet my cases are not alone. My cases are not unique. They're just the cases I know. This happens in a lot of cases. This has happened in numerous cases from Alameda, Curtis Irvin's case, and Maurice Boyette, and Jack Friend. This has happened in a number of people's cases. I think groups like DPF, putting a spotlight on it and putting pressure on the politicians and telling them, look, we expect better from you. You know, we expect better. When we elect someone to be a California Supreme Court justice, we expect you to uphold the law and to impose a penalty when people go outside of it, even if they're the prosecutor. I think that's something that needs to happen more, so that the court understands that we don't just want rubber stamps. People want justice.
Well, that's the. I'm sorry. Go ahead.
I agree with everything you said. I think, everyone here, I'm assuming most of the people watching, and we all here are anti-death penalty, but I think whether you're pro or anti-death penalty, we should all just want fair trials for people, right? Like, this isn't just taking someone into court and railroading them to get a conviction or a death sentence. We should want our prosecutors to be, as Brian said, looking for justice and upholding the law and following the Constitution in order to get a conviction. And if they do it that way and they get a, conviction, and the law says, the death penalty applies, like, again, I am anti-death penalty. I'm always going to be. But for people who are, at least that they can say, well, this person had a fair trial. And it wasn't just rigged against them from the start.
And it's not just 40 years ago, Mike. It's not just Rose Byrd 40 years ago. As you said at the very beginning, Pam Price is looking at a recall election in November. She's going to be on the ballot for a recall election in November. And so part of if I were a voter in Alameda County, one of my questions would be, do I want this kind of practice that went through at least 3 administrations before her, right? Jack Meehan, who was the DA from 81 to 94, a bunch of these cases were in his administration. Tom Orloff, who was the prosecutor from 94 to 2009, a bunch of these cases were in his administration. Nancy O'Malley, who was the prosecutor after them, whether this was happening in her administration or not, I don't have an opinion on that yet, because we're still working our way through the later materials. But I'll say she had these documents. All of these people had these documents. As you said, Ernest Dykes has been there since 1995. Yeah. So these people had these documents. They could have come out. They could have brought this to light decades ago, and they chose not to. And so we have to ask ourselves, do we want our office holders to be people who either discriminate or bury the discrimination, or do we want people who have courage to bring it out and to say, this is messy, but there's constitutional rights and we got to do it correctly? I think that's something that we need to challenge ourselves and challenge our neighbors and our friends to look at and say, what do we stand for, and how do we really want things to work?
I couldn't have said it better myself. God bless you. That's this is quite extraordinary to hear from you who go through this process day after day after day and are exposing the rot in so many of these cases. I can't tell you how much it means to those of us who are trying to seek justice in a society without reducing ourselves to the level of those who have to kill in order to do it. But whatever the case, what we all want to see, as I think Ann-Kathryn just said, is we want to see justice. We want to see just responses to inappropriate behavior in society on the parts of people who, for whatever reason, choose to step out of line. But none of us want to see this kind of junk where prejudice and bias and twisted thinking and an attempt to get over is ruling the day. I'm proud to hear from the two of you and know that there are attorneys out there, as I know is the case, attorneys out there who are willing to take on these questions and willing to call what it is. And it means a great deal to me that you've taken the time to come on with us and talk about this and explain what's going on in the cases you're dealing with, because it opens some doors, I think, for other people to think about what's happening in the cases they're dealing with. You are your heroes in my book. Thank you very much for taking the time to be with us today.
Mike, I'm wondering, we have just a few minutes left, and I wondered if I could just ask our panelists a couple of questions in our Q&A that came in. And I think we have time. Yeah.
If you're willing to take the time.
Absolutely. Sure.
Great. Okay. One of them I thought was actually the one that I had in my mind, so I'm a little prejudiced on this, but when you mentioned the AG's office, Brian, Bonta made a big deal about establishing a conviction integrity unit. And I wondered, wouldn't that be an appropriate place wouldn't that be appropriate for him to put his conviction integrity unit to work on something like what's going on in Alameda?
I think so. I mean, I don't. I think so. I think it depends. A lot of conviction integrity units look only at pure innocence cases. Now, I will say, in some of these cases, we have people who have been proclaiming their innocence since day one. I mean, in a couple of these cases, there are people. Actually, a few of these cases, there are people who've said since day one, "You got the wrong guy," and it's as disturbing as this is on a whole. When you combine that with the possibility that if you have the wrong person and you're rigging the jury, the chances of getting a conviction are higher, it's even that much more disturbing. So I think it could be something for its conviction integrity unit. I also think it's something just for him to look at and say, look, as a whole, we shouldn't be here to fight every case, right? That shouldn't be what the Attorney General's office is. It's not our job to make sure everyone stays in prison. It's our job to make sure that the courts got it right and that there was justice for these people, right? They're the Department of Justice, the California Department of Justice, not the California Department of Protecting Convictions. And so I think that, yes, Mary Kate, the CIU would be great, but I think it could be a wider thing too, of just saying, do we have concerns about this? I mean, if this is a case that looks, I don't know how you could not be concerned about some of this, right? Even exclusive of the documents that we got, how can you not be concerned when you hear 7 of 8 blacks and 6 out of 6 Jews in one case are struck? How can that, the last 9 strikes by the prosecutor in that case were black, black, Jew, black, Jew, Jew, black, Jew, black, I think. It's incredible. It's 9 strikes in a row of blacks and Jews. I mean, it's just an appalling display. And yet that's a case, so you all know, Charles Stevens is out of appeals. Charles Stevens lost on his Batson claim in the trial court, in the Court of Appeal, in the California Supreme Court, in the federal court. In the federal court said, I think one of these, only looked at 3 of the black jurors, didn't look at the Jews or the other black jurors, only looked at 3 of them for procedural reasons. He was limited in what he could look at. And he said, I think one of them was improperly struck. So you have a federal judge who said, I think there was a Batson error here, but then because of federal procedural rules said, I can't give relief. So even where there's an error, you have problems in giving relief. He then lost in the 9th Circuit, and I petitioned to the Supreme Court, who didn't take it. So now you have an individual who, but for the grace of Gavin Newsom's moratorium, would be dead before we even got these documents. The only reason Charles Stevens is still alive is because of the moratorium. And so now we're getting proof of the systemic nature of it, but we knew beforehand. I mean, it does not take much to look at this and say something here is wrong. Something here is not working. And so I think for the Attorney General's office, looking at cases like that and saying, there's a problem here, and we need to acknowledge there's a problem here, not just protect our win. We need to acknowledge there's a problem and say, did they do it right? You can retry individuals. This is, you give them a fair trial, and if a jury convicts them, then there's no cause for concern, right? You have your conviction without cheating for it. I still would disagree if they got the death penalty, because like Ann-Kathryn, I'm anti-death penalty, but at least give them a fair trial, at least give them a fair chance.
And let's not forget, just jumping off of Brian's point about Mr. Stevens being out of appeals, let's not forget that there are several individuals who have died while on the row, who are involved in these cases, right? So Fred Freeman died. One person was executed, and I'm sorry, I don't have the name off the top of my head, but Brian.
David Mason.
Yeah. So, as much as we're doing what we can to hopefully resolve these cases now for the people who are on the row, I think that it's important for us not to forget that there are several who never got the opportunity that some people have now.
A lot of Alameda capital clients died on the row. And like Ann said, Freddie Freeman, who was the hearing, that was the case Jack Watman prosecuted that we talked about. Fred Freeman died on the row, right? He never got his justice on this case. He never got his fair trial.
Mary Kate, do we have any other questions?
Yes. This one is, does the exclusion of Jewish jurors fall within the Racial Justice Act, or does the act only apply to race?
And no.
Brian, I'll let you take that one.
I have pled this a lot. I mean, the Racial Justice Act, I believe, is just race, but I have pled that Jewish is a race. That it applies to race and ethnicity, and Jewish is a race and ethnicity. My argument that I've made to the courts is, I believe Judaism is a religion and Jewish is a race and ethnicity, and that's and I'm Jewish, so that's my take on it. But that's the argument I've made. I think there's support for that distinction.
I like that. I like that distinction.
If you look, Mary Kate, if you look, there's a lot of famous Jewish people who don't practice Judaism, right? Yeah. They don't go to temple. They don't, they're agnostic, but they still consider themselves Jewish. Mm-hmm. It's not, even though they're not religious at all, and there's there's a long list of folks who fall into that group. The so I think it's a fair distinction to make. So in Mark Schmeck's petition, I did it as a Racial Justice Act claim, and it's based on his on the jurors who were struck being Jewish.
This one is from a person in Canada who mentions a person who was tried for killing an Aboriginal person in Saskatchewan, and the defense got rid of every Indigenous juror. And the Crown ignored local statute requiring 2 jury pools. The federal government, in response, eliminated peremptory challenges altogether, and that was upheld by the Canadian Supreme Court. Could that happen in the United States?
It is happening in some places. Arizona got rid of peremptories recently, and my anecdotal what I've heard from there is it's working out well, but I don't have firsthand knowledge. And
Yeah, I don't have firsthand knowledge other than what Brian said, like that it is happening in some places, and there are movements to kind of push legislation to get rid of peremptory challenges in places.
So the peremptory challenge is not a constitutional right. It's not like in the Constitution that it can be just decided. Oh no, we're not going to allow that anymore.
yes,
Oh my God. Okay.
yeah, I mean, look, the voters of California could go write a proposition and get rid of them.
Oh. Oh, I hate ending on a downer.
I don't think that's a downer. I think that's a challenge. I think that's a challenge for DPF's constituents to take up. That's something that people can do. That's something where people could make a difference. They could say, you know what, we don't want to give you this power anymore because you're not wielding it properly.
Oh. Okay.
I'm trying to put a sunny face on it for you, Ricky.
I really appreciate it. This one, I just had to ask you one more, and I promise we'll end. But this person asked, can you tell us where any of these offending prosecutors are these days? I'm concerned if they've been elected to the bench.
Great question from
Yes.
someone who may know. Yes, some of them got elected to the bench. One is currently on the bench in Alameda County.
Oh.
And one was a longtime judge who passed away last year. So yes, and actually, and others have been judges, not just those two. I mean, there's been prosecutors are frequently become judges. So yes, a lot of folks involved here became judges, and one of the claims from Jack Botman was that the judge in his case was involved, right? That the judge was the one who had instructed him not to have Jews on his jury. And I think we've seen stuff that raises concerns for us in other cases as to whether judges were involved and conduct of the judges. And I think a number of activist groups penned a letter to the California State Bar asking them to look into these prosecutors and into the judges who the prosecutors who are now judges. And it's I think there will be an inquiry into these folks.
That isn't it the case that the one who was cited, the judge who was cited, was himself a Jew?
Yes.
Yes.
Stanley Gold. Yes.
And he used the Eichmann case as his example of why no Jew would give the death penalty.
Correct.
Wow.
Yeah. It's
well,
but like you said, that's that information, Mike, which you're referring to, comes from a New York Times story written in 2005, and here we are today. It took 19 years for this to come out. This shouldn't have taken 19 years to come out. I mean, this is 19 years of injustice, and it's not fair to anyone. It's not just our clients it's unfair to. This is especially unfair to the victims' families.
Yeah.
This is especially unfair to them. The fact that these cases now are going to have to be, some will be retried, perhaps. Some, some folks will get, maybe they'll deal out for reduced sentences. I mean, there's a whole panorama of possibilities here. It's unfair to them. It's unfair to everyone that the prosecutors didn't do their job that they were entrusted to do.
Mhm.
And when they do that, the Alameda County court system is broken. I mean, this is not, you have judges involved, you have prosecutors not doing what they're supposed to do, you have defense attorneys who in some cases were people who had been in the prosecutor's office for years. I find it very hard to believe that those defense attorneys, when they saw this happening at trial, didn't know what was happening, right? And yet, where are the objections from some of them? Some were objecting, some weren't. And so I think this is a good representation of a broken system.
Indeed. Well, thank you so much, Brian Pomerantz and Ann-Kathryn Tria, for the work you're doing. You are, as far as I'm concerned, and we at Death Penalty Focus thank you for your heroism, and for your just simple decent good work. Thank you very much for your time, and God bless you, and continue, please.
Well, thank you to you for what you're doing at Death Penalty Focus, Yoko and Mary Kate and Mike. You guys do incredible work. You bring attention to things. Us writing these pleadings and filing these things, as we've seen today, frequently does not have the effect it should. And so, to the degree that people care and people put a spotlight on things, that makes a big difference. So, thank you so much.
Yes, thank you. Thank you very much.
Pleasure. Thank you.